Courts stand at a crossroads between tradition and necessity. On the one hand, we are guardians of legal boundaries, carefully distinguishing who may practice law and what constitutes legal advice. On the other hand, we're confronted with an undeniable reality. In many locations around our country, people with legal problems never even reach the courthouse door. This is because of a variety of reasons. They live miles away from the courthouse or even any legal help. They cannot even afford to get the legal help that they need. Or they do not even see their problem as legal, or that the courthouse is a place that can help them. As unmet legal needs grow, our community is asking courts to do more, to do things differently, with fewer resources, and with fewer assumptions about how justice is accessed. These questions invite us to wrestle with uncomfortable issues. If non-attorney legal advocates are helping close critical legal gaps in selected areas around the country, is the current limitation on giving legal advice, such as in NACM's Model Code of Conduct for Court Professionals, Canon 1.7, still appropriate? Conversely, do some areas of law require stricter boundaries to protect the public? Can we continue to rely on courthouse-centered models, or must courts extend their presence into the community in more sustained and meaningful ways? And as frontline staff increasingly become the first, and in some cases the only, point of contact, how do we responsibly navigate that thin line between providing helpful information and giving prohibited legal advice? Finally, this discussion challenges us to think about the future of our courts workforce itself. Expanding non-attorney legal advisors raises questions not only about service delivery, but about professional identity, training, liability, and career development within the courts. Are we prepared to redefine roles, invest in training for new skills, and accept a more flexible vision of how we as court leaders serve the public? The answer to these questions may shape not just the access to justice, but the very role of courts in our communities. I'm Pete Kiefer, and welcome to A Question of Ethics, a conversation on courts and ethics. In this episode, we examine the expanding role of non-attorney advocates and community-based services. We look at the evolving role of court staff to meet people where they are, and we ask the question, can we reimagine access to justice? Here to discuss these issues are Maggie Hum, Executive Director of the Alaska Legal Services Corporation in Anchorage; Sarah Carver, Co-Director of the Alaska Legal Services Corporation's Community Justice Workers Resource Center; Credell Webb, Diversity, Equity, and Inclusion Officer for the First Judicial District Court in Philadelphia, Pennsylvania; and Liz Rambo, Trial Court Administrator for the Lane County Circuit Court in Eugene, Oregon. Thank you all for joining today's Question of Ethics conversation. The ABA reports that 70 to 80% of people with legal issues never even attempt to resolve them through the courts. Dr. Rebecca Sandfer has noted that many individuals no longer even frame their problems in legal terms or view courts as a venue to help them solve their problem. Now, we court leaders emphasize access to justice. Yet within this mantra lies the assumption that people must come to the courthouse. If most people do not naturally see the courthouse as a place to address their legal problems, should we in the courts start rethinking our approach? To truly fulfill our goal of access to justice, do we need to extend our services into the community rather than relying on people coming to us? Credell?
Thank you for that question, Peter. And I think when it comes to courts, we don't have unlimited resources. So in many cases, courts look to have some form of community outreach, but it may not always reach everyone. And so that can be a difficult thing. So what I think is that we should go for any of the low-hanging fruit we have. For example, any ways that we can make our forms clearer using plain language, ways that we can update our websites to ensure that individuals can understand exactly the information that we're trying to communicate to them. If there's any pamphlets we can hand out or information for self-represented litigants to use law libraries or community legal services. even when resources are tight and there's budget constraints, I still think there's that low-hanging fruit sometimes, those little changes that we can make. And so I think courts just have to be adamant about doing that. And then if there are opportunities where they get additional funds, where they can reach out to the community, then I think it's a great idea, because people do need assistance with their legal matters. And oftentimes an attorney can be very expensive. Even worse, you have some people where if they are low income, they may be able to have access to community legal services, but those folks who are in that mid-income don't have that access to community legal services, and then they're unable to afford an attorney. So they're sort of stuck in this place where they may want to interact with the court, but it's just totally financial. And if we have ways to make the process easier for them to represent themselves, maybe the law library, clearer forms, or maybe some states are doing like legal lines where you can call legal services and get a little bit of help or a little bit of information. We also have to partner with our bar associations to see how they can help too, because although the court is neutral, there may be organizations that we can partner with so we can send people there to get the help and the services that they need.
Many jurisdictions limit non-attorney legal advocates to specific areas such as landlord-tenant disputes, debt collection, foreclosure, employment, and Social Security benefits, to name a few. Should there be areas of the law where these advocates should not be allowed to assist? Sarah Carver?
I think when I take a step back and think about this question, it helps me to analogize the practice of law with the practice of medicine. So in medicine, we have many different areas of practice. You could be a paramedic, a nurse, a CNA, a brain surgeon. And is every medical practitioner doing the same level of service? Of course not. We don't have paramedics doing brain surgery. It helps me to think of the community justice worker project through the same lens. There are a plethora of areas where a properly trained community justice worker can be highly effective and make a very big impact on a person's legal issue. And then when they need to, when they encounter a legal area that they're not trained for, they can refer up to a higher level provider. Alaska specifically is not a jurisdiction that limits community justice workers to a particular practice area. We have in Alaska Rule 43.5, which is the waiver to engage in the limited practice of law for non-lawyers trained and supervised by Alaska Legal Services. Again, a lot of words, but the rule itself does not actually limit the specific area of law for which the community justice worker can be certified. It does, however, have a few guideposts. First, the community justice worker must complete a training that Alaska Legal Services has provided. They must also complete a training in professional conduct, which includes conflicts of interest, confidentiality, and duty of candor. They must be supervised by Alaska Legal Services. They must be providing assistance to an Alaska Legal Services client, and then they must engage in the limited practice in the area for which they were trained. So I like the way this rule is set up because it's a low barrier rule that does not unnecessarily limit the area of potential practice without an evidence-based reason for doing so. So in my mind, this really helps the legal profession in Alaska stratify in a similar way to the medical profession, where we can offer services commensurate with the actual needs of the client at that time.
The maxim, "do not give legal advice," raises the question, exactly what counts as legal advice? One common rule of thumb was to warn staff that if they ever found themselves saying, "in your particular situation, I would recommend," that's the moment that they've crossed the line into giving legal advice. Another was that if the information wasn't something you would give to everyone, then you're probably likely giving legal advice. How do you train your staff to recognize the boundary? What is the liability for giving incorrect advice? Credell?
I think many courts now have legal forms that have the legal information. I know, for example, in our court, you might have a form about small claims, how to fill a small claims form out. Anything that's on that form that we're giving out or that's on our website, that's legal information. Legal advice would not be on those forms. And I think if a person isn't sure, at that point, they would want to check with their supervisor. Also, people may define legal advice differently. So that's why I say if you're on the fence, check with your court leadership, check with that supervisor. Don't try to figure it out on your own. And I think some of our employees and staff members who have been here longer, they may have a better understanding of where that line is. But let's say when we have newer staff members that come in, they may not know where to draw that line. So even if you don't know, the safe side is to come and access someone within the courthouse who knows where to draw that line. And so oftentimes I would train my staff using the forms. And then if you don't know, come to me and I'll come out and handle that situation on a case-by-case basis and have the staff member watch me handle it and take notes. So that way they can see how to deal with that particular interaction.
Liz?
I think I mentioned before, in Oregon, we have some longstanding programs for providing legal information to people, particularly in family law cases. Decades-long family law assistance programs that are statutorily authorized, and that statute then defines that providing assistance in that way and giving legal information is not considered engaging in the practice of law under the statute. So we've been doing that for a long time. We have very intensive training programs. And I just think it's important to just continually train staff to understand the difference between legal information and procedural information, and that you can provide and should provide, and telling people what they should do in their particular circumstances. And in Oregon, there's no particular liability for getting it wrong, but the risk is reputational, right? And that's the huge problem. So we need to make sure that we get that information right when we give it out to people.
Consider the scenario of a person coming to the counter and saying that they're being sued by a debt collection agency and they don't know where to turn. Would it be considered legal advice to ask whether the person has explored the possibility of bankruptcy? Gradell?
Oh, I'm going to go with yes. You should not say something like that. Have you explored the possibility of bankruptcy? Because here's the thing. That may not be appropriate. And the fact that you work at the court and you say that, they may think I need to file bankruptcy. They may, worst case scenario, try to file it on their own without an attorney and without knowing anything about that person's situation. They might have had many other resources they could have used that might not be appropriate. So I would not do something like that. I would not say something like that. If I heard one of my staff members recommending that, I would definitely have to sit down and talk to them about that type of advice to someone, because it seems harmless. Maybe they know about a little bit about Chapter 7, but you don't know that person's circumstances. Secondly, we're not in a position as court employees to say something like that, because imagine maybe the person files and that was the worst thing for them, and you put this person in really bad shape. And as Liz was saying, that's our reputation. That's our reputation here at the court. We don't get that back, and that decreases public trust and confidence.
Liz?
Oh, I completely agree with everything Cradell said, especially when he said he agreed with me.
Very good.
No, I completely agree. I mean, if I heard my staff recommending a particular forum or type of proceeding, that would go beyond what we would expect them to do.
Traditionally, a career in court administration has meant moving through a hierarchy from line staff to supervisor to manager and ultimately court administrator. Could becoming a non-attorney legal advocate represent a new career path for court employees? Should courts encourage staff to pursue paralegal or legal advocacy training alongside the traditional administrative track? Gradell?
So I think if the courts were promoting staff to do this, that might be a little bit competitive. So I don't see that role being within the court, but I could see that role being a role that certain court employees may want to pursue if it is available in their jurisdiction. But I will say everyone would need to be cautious depending on the state that they're living in, because the state of Washington had a limited license legal technician program that they started in 2012. But then that program was abruptly ended 8 years later by the Supreme Court. They decided to do away with the program, and they were not letting any new persons join. And so you do have to be careful that this can be a slippery slope depending on what jurisdiction you're in, what the Supreme Court thinks, what the Bar Association thinks. And again, that's not to be a downer, because there are other courts that are doing this. There are other states that have, not other courts, other states that have the programs that are booming. So for example, the state of Minnesota just started what's called a legal paraprofessional pilot project in 2020. It was like a 2-year pilot. And they put a committee together, and then in 2024, they made their program permanent. And they have many stipulations about who can be licensed, and they handle certain, these are non-attorneys, and they handle certain landlord-tenant cases and some family law. So it just really depends on where you're at. I think these matters are very complex, and the answers aren't easy. And I may have mentioned this to you, Peter, offline. As an attorney, my brain always thinks, this is unauthorized practice of law. We can't do it. I also live in Pennsylvania, and our rules are very much against it. But also, I work in the field of diversity, equity, and inclusion. And I'm always thinking about equity and inclusion and legal deserts. And people do need assistance and resources. And so how do we bridge that gap? Yeah. It's not an easy question, but I wanted to give you both of those aspects, because some people feel very strongly on one side or the other. And I think there's a lot of gray area here, and it's not as black and white as we all think.
Liz?
Absolutely. And also, I have to say, I encourage people on a lot of career paths. Yes, a lot of career paths, because court management career path itself has a limited opportunity. And so if people who work in, say, our family court assistants want to pursue additional education about becoming a limited legal services advocate, if we had a program like that in Oregon, I would encourage that for them, but it wouldn't be in the court, right? Because we don't advocate for people within the court system. So yes, and.
What advice do you have for states that are considering this model for assisting litigants? Maggie?
Well, I think in listening, to Liz and Credell today, I want to say, like, they understandably have concerns about this being like community justice workers being, sponsored by the court system, or, actually court system employees. And I think that's, that makes sense. I hear those concerns, but I will say, and, I mentioned this a little bit, but I think it's incredibly important to understand how supportive state court systems can be in getting these efforts off the ground, working with local service providers, the local legal aid providers. There is a huge role for the court system in this effort because we're all in it, right? This is going to take all of us. It's not just legal aid, it's not just the court system, it's not just the Bar Association. It really, it's going to take all of us to help to close this justice gap. So I just wanted to emphasize first that I think the court system does play a really, really important role in supporting these efforts, even if your own staff can't be CJWs, even though maybe we can figure that out someday. But then I just want to, emphasize secondly that I know this seems like a big thing to bite off, but I think it's doable, and now is the time to do it. Legal aid organizations are we're already stretched thin, and I think there is a real possibility in the coming months and years that legal aid organizations are going to be even more under resourced than we already are, with threats to our funding. So now is the time to jump in. And I think the good news is that there is a growing body of research out there. You mentioned Dr. Sandifer, who we work closely with, in addition to others, in researching this topic. And there are a lot of ways that your state court systems, your state bar associations can get the support that they need, both in terms of advocating within your state for the community justice worker program, and providing the technical assistance to CJWs and the organizations that support them.
Credell?
Maggie, you had a lot of great things to say in terms of the courts and all of us playing a role together. And I think most of my commentary has been with regard to the line staff and the people working at the front and making sure that we stay neutral. But one thing that I would recommend for other states that are trying to get these models off the ground, look at what some other states have done and look at other states to see where they're successful, and look at other states to see where they failed. One of the things that I find that's common among most of these states is they've all sort of developed either pilot programs or committees. And when they form these committees, they come up with all these types of ideas. I mean, there's so much research out there, and figure out what went right with those committees and how they were able to get these programs off the ground and try to mimic some of that. If you're looking at states where you see a lot of things have went wrong, or maybe there wasn't enough champions, try to find ways to avoid those things so that you can bring it to the table. And then, as Maggie said, bring all the stakeholders, the courts, the bar associations, the defense attorneys, the private bar, bring everybody together to see what the pain points are. Because sometimes we assume something that may not be true. You may assume that attorneys don't like this. And then I'm listening today and it's like, no, our state bar supports this, right? So we could be all making assumptions without bringing the stakeholders together. And I think one thing that I found in common was just there were so many committees and they were bringing different people to the table to talk about these things. And so look at the case studies because the information is out here. We may have only discussed a few states, but in my research, I was looking at a lot of different states that programs either failed or they're either successful. And then we're listening today. So things like this, listening to these types of trainings, these recordings. I'm sure if I was in a jurisdiction where this topic was coming up, I would want to listen to a podcast like this to just see what some of the angles are. So Peter, thank you for thinking about this topic because it's really good. And my panel members also, I'm learning a lot from you all, just listening to the various perspectives. And I really like it because one thing that stood out that Sarah said when she compared this to the medical field, and I didn't think about it like that. Like, yeah, like there's different roles that people had. Everybody is not necessarily the person that's the doctor or has to do everything. Other people can help out. And so this is a really good topic. And I would encourage states to just be as informed as they can to make an informed decision. Don't be so quick to say no. Don't be so quick to say yes. Figure out all the variables and see what it is that you can do.
Sarah?
Building off what Credell is saying is you don't have to do this in a vacuum. You shouldn't be doing this in a vacuum. If you're a state or a program that's interested in community justice work, there are a lot of resources out there. There is a Frontline Justice, which is doing this work on a national scale and working together with different organizations in different states to move community justice work forward. I think my advice is it's okay to start small. You don't need a court rule like Alaska. We didn't have a court rule when we first started community justice worker program. Every state can have community justice workers operating in public benefits. That does not overstep anyone's unauthorized practice of law issues because a public benefit client is entitled to the representative of their choosing, and that does not have to be a lawyer. I think the other piece of advice I have is partners are really key. This work needs to be born out of the communities you're serving. You should be doing this in lockstep with community organizations so that you are effectively reaching the needs and wants of the communities you're trying to serve. And when you're accessing the right partners and working together as a community, there's much more trust in what you're trying to build and buy-in from the folks you need buy-in for to move the project forward.
Liz?
Well, I always dislike going last because I've heard all the great things that everyone said. And so in some, I would just like to say what everyone else said. No, I would add to that. Be creative. That's, if I could say yes and to everything my colleagues just said, I would say also be creative. Because it's easy to see, Washington has the ideal program and we want to do that. And then you immediately run into systematic barriers, whether they are intransigency, wrong word, intransit, you know what, never mind. And don't even bother cutting that. Intractability in the legal community, whatever it is, budgets, that gets in the way. But whatever it is, and I think Sarah hit on this a little bit, don't let the perfect be the enemy of good. Do something to start working on this. And if I could give just a little story example of that. In Oregon, recognizing legal deserts, last year, the Bar Association, the court system, and the major law schools in Oregon, there are 3 major law schools, got together and did a teeny tiny little 1L, first year law student, summer extern program with 3 summer externs that were sent out to rural communities and paid for their summer to live and work with lawyers in these and the courts in these local communities. And it was a big success. And now everyone's talking about how to find more funding to do more of that. So be creative, do something.
A heartfelt thank you to Maggie, Sarah, Liz, and Credell for sharing their viewpoints regarding non-attorney legal advocacy, community-based services, and the evolving role of court staff. I'm excited to see how we do successfully reimagine access to justice. And to you court professionals tuning in today, your commitment to service, fairness, and access to justice is the bedrock of our court system. Through your patience, professionalism, and compassion, you ensure that the courts remain open and responsive to all who seek justice. Thank you for the difference you make every day. Thank you all for participating, and we'll see you on the next episode of A Question of Ethics Conversation. Thanks for joining us today. The Question of Ethics Conversation is a periodic series on ethics, courts, and court administration. Today's episode will be available on our website, on the Court Leader website, on YouTube, Facebook, iTunes, LinkedIn, and on Instagram. Did you enjoy today's conversation? Please share the link to the episode on your social media pages. Every share helps spread the word about the important topics of ethics and court administration within our communities. Become part of the conversation. If you have questions, comments, or ideas for future episodes, email us. Our address is ethics@nacomnet.org. You're also always invited to join the Question of Ethics conversation held after each Ethics Committee conference call on the fourth Thursday of every other month at 2 p.m. Eastern Time. Did you hear an interesting comment by one of the panelists that you would like to review, but you don't want to search the entire episode to find it? The Additional Resources section of the webpage has a complete transcript of today's episode with the time markers for when each question was asked. Find the discussion question on the transcript, and next to it is the time that question was asked. You can either review the comments on the transcript or listen to the panelist's comment on the audio or video recordings. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leaders website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.